I started looking at ChatGPT, and like everyone else, like all the other attorneys that were out there, at least all the other semi-technical capable attorneys that were out there, we kind of started looking at it like, what can this do, right? And it started out by making simple requests, but because I have, the fairly small coding background, I tried to take those requests a little bit more. So my requests started getting more and more complex, and I started doing more and more research on how to use it in the way some other people in the non-legal fields were using it. And then it turned out that some of my experiments actually bore some fruit. And so instead of going the machine learning route, I developed the algorithms required to put together some of our AI drafting portions, and then got the utility patents on them and incorporated them into the software. So I didn't find it, it found me.
Hello, everybody, and welcome to another episode of the Everything AI and Law podcast. So today I have with me a special guest. His name is Aaron Cartwright. He is an attorney. He is the CEO and president of CaseCrafter.net, but soon to be CaseCreate.com. Hello, Aaron. How are you doing?
Hello, Tolu. How's life? I'm doing quite well. I've been listening to your podcast in preparation for this episode, so I'm looking forward to this.
Awesome. So are you ready to talk about the impact of AI in the legal industry?
Absolutely. It's been the focus of the other half of my waking hours since November, December 22. So yes, let's get to it.
Okay, so right away, why did you decide to go into AI? You are an attorney, so why AI as an attorney?
So this long story short, well, actually, let me begin where all good stories begin, when I was but a twinkle in my father's eye. And then I decided to go to law school, and then for some strange reason, I opened up a law firm. But no, so here's kind of the way this whole thing happened out, which was that I, like every other attorney, had I needed a way to do things, right? So every attorney has their database that they use, their library as it may be called, where they've got, template motions, template orders, templates for documents, templates for everything. And I didn't come from a firm. I created my own firm almost immediately after passing the bar. So I didn't have a database or library that I could draw from already, so I had to make my own. So I started out by finding the types of documents that I would need, and as my practice grew, I would just gather more and more templates so that I wouldn't have to start from a blank page. Well, that grew and grew and grew, and then I hired an associate. Well, my associate really needed access to she already had access to the template library, but I needed something that she could go through and use without having to sort through all the templates. If she was drafting late at night and I wasn't available, then, she would have something that she could do or accomplish or finish something without having to wait until the next morning, just in case we had something due immediately. So I reached out to a friend of mine, and we started putting together the early versions of just consolidating all of my templates into a product that my associate could access a little bit faster than my regular template library. After a little while of developing that, we kind of sat back, looked at it. We basically told ourselves, I think that we've got a commercial product here, something that really makes it easier to draft that isn't like what's currently available on the market. Well, we spent some time developing that, and then I took it to a friend of mine who worked at one of the big white shoe law firms, making a whole bunch of money, whole bunch more money than I make, but took it to him and asked him, well, what do you think about it? He said, this is great for if you're a small practitioner, if you've got a smaller practice, but the larger firms, they've got, bigger or more resources, bigger libraries. They want us to do things a certain way. And then he said, what would be really awesome, though, is if you could create something that drafted complex motions. Motions for summary judgment, briefs for different things, and I sat back and I told myself, okay, well, let's start thinking about this. So I remember that being sometime in 2022, middle to late 2022 because I remember it being cold outside when he told me that. Um, so I started thinking about how to draft complex motions using machines. And basically the reason why I started thinking about that, because I am a huge fan of, if you have a difficult task, give it to a lazy man and he'll find an easier way to do it. So I, supremely lazy, I want the easiest way possible to do things and still get them done correctly. So at that point in time, the only avenue that we had for drafting the more complex motions, it was kind of a machine learning output, okay? And the reason that we could do this with machine learning is because at a certain point in time, all motions are, all pleadings are, most of the things that you find filed in a courtroom are, judge, here's my request, here are the facts that surround my request, and here's the law that allows you to make the ruling that I want subject to my request, okay, based on these facts. And if you know how to structure, the paragraphs, the way that lawyers write, conclusion, rule, explanation, analysis, conclusion, or issue, rule, analysis, conclusion, it's structured fairly similarly. So once you kind of have the law in one spot and an explanation in another and an issue in another, once you know how to put all those elements together, you can generally tell a computer how to do it. Well, I didn't so much find AI as AI found me, because right after I started doing the, just kind of technical diagrams for putting this together, ChatGPT hit the scene in a large way around December 22-ish, at least for me. I'm certain that they were around beforehand, but it was December 22 for me. So I started looking at ChatGPT, and like everyone else, like all the other attorneys that were out there, at least all the other semi-technical capable attorneys that were out there, we kind of started looking at it like, what can this do, right? And it started out by making simple requests, but because I have, the fairly small coding background, I tried to take those requests a little bit more. So my requests started getting more and more complex, and I started doing more and more research on how to use it in the way some other people in the non-legal fields were using it. And then it turned out that some of my experiments actually bore some fruit. And so instead of doing the machine learning for CaseCrafter, or Case Create as it's going to soon become, instead of going the machine learning route, I developed the algorithms required to put together some of our AI drafting portions, and then got the utility patents on them and incorporated them into the software. So I didn't find it, it found me.
Wow, that's when I watch a movie and they're like the story of from maybe not from grass to grace, but basically something inspiring. But this way, it's a lawyer and a techpreneur, something like that. So the story is well, maybe because I'm very imaginative. So as you were saying the story, I was just like writing the script in my head. But yeah, that's an aside.
Am I selling you the rights? Is there going to be a movie about this later? I promise you, it's a whole lot of sitting behind a computer and one restaurant visit, and that's about it.
But it's yeah, I mean that's what the movie's about. Maybe like the Silicon Valley CEOs about. It's just yeah. So there's no difference to me. Okay, so yeah. Now maybe using case create as an illustration point. How do you believe, or from your perspective, how is AI gonna shift, or like literally impact the legal field? I know it has already started, but from your perspective, how has it, and how would it continue to reshape the legal field?
So I agree with you. It has definitely already started, and I try to keep my finger on the pulse of things. So one of the biggest impacts you're seeing right now is in the transactional space. There are a large number of, or small number but large enough, but there are a number of AI softwares that are out there that are currently helping draft documents for all sorts of transactions, everything from business creation to general business contracts, vendor contracts, M&A. Spellbook is chief among them, and there are a number of others. But one of the primary impacts that we're seeing is just ease of use, or not ease of use, but rather speed, right? So, and we may get to some of the ethics about that later, but it's it's basically helping attorneys draft more complex documents a lot faster. Now, this should reflect in the client's wallet, in that the client should be able to see some sort of reduction in attorney's fees, or they should be able to get a larger number of attorneys that are able to handle smaller value requests more efficiently. But I don't really do transactional, so I'm going to leave that for them. But I do litigation. On my side of life, we are seeing number one, a large amount of fear. So you heard the story, or I think that some of your listeners may have heard the story coming out of a couple of different states in 2023, where you had at least one or two different attorneys that had written entire briefs and entire pleadings, and those briefs and pleadings had completely made up law in them. Okay, I figured this, not to toot my own horn, but also to toot my own horn. I found out pretty early that ChatGPT wrote the most beautiful case law ever, but then when you went to go check the sites that it gave you, none of those cases existed. And so I was pretty disappointed about that one. But apparently that lawyer, or those lawyers, did not go check those sites. And then whenever they got asked by the court to draft an explanation or something like that, they used ChatGPT to draft the explanation. So instead of realizing their mistake and apologizing, they doubled down. That's kind of slowed the growth of AI in litigation, but obviously we've ignored that or taken advantage of the fact that no one else really wanted to touch it. So we've got something that will help draft discovery, draft demand letters, draft general pleadings, MSJs, appellate briefs. We've got TROs coming soon and some other discovery-related items. But one of the hopes that we're going to see is speed, and we're going to see we hope to see some more transparency between attorney and clients. And you didn't ask this question, so I'll only briefly touch on it. But the idea is to see a little bit of a more transparent pricing on one side, so that an attorney can say, hey, this is my price for this document. This is about how much a lawsuit will cost. But the other concern that we've got is access to justice. There are a number of instances where someone like, even myself, I've only been practicing for 7 years. My deposits are anywhere between $2,500 and $5,000 depending on the matter. Well, if you as a client come to me and say, well, I'm missing $5,000, this person didn't pay me, I say, okay, that's, unfortunate for you. You've got a case. There's a high likelihood of, you being able to win, so on and so forth. But the deposit is what's going to kill you. The $2,500 or $5,000 that I'm going to ask for, depending on whether or not your opposing counsel or the opposing party has money, you may be throwing good money after bad. It's going to cost you $5,000 for me to go get $5,000, and there's no guarantee that you're going to be able to collect, but there is a guarantee that you're going to have to pay my bill. So, with something like Case Create, or with AI in general, what I'm anticipating and what I really want to work towards raising interest in is the idea that an attorney can come out, or even paralegals, because paralegals are about to have the ability to practice small cases in Texas here soon. One of the things that we're looking forward to is being able to help practitioners, no matter where they be able to handle some of those smaller dollar value cases more efficiently. If you take 100 JP cases in a year and you charge $1,000 for each of them, you can knock those cases out extremely quickly in JP court and still make $100,000 a year without having to deal with the same timelines that you would get in a different level of court. So that should hopefully help.
Yeah, I'm glad you actually already touched on the question, because that was my next question actually. AI in
Sorry,
litigation.
I rambled.
No, it's okay. It's perfect. So, now the first thing is, so AI Case Create, for example, helps with document drafting, helps with e-discovery, helps with evidence management. So I just want you to, maybe in a nutshell, just explain how useful AI will be in litigation, maybe using case create as an example. So people who don't maybe know what to use AI for in litigation and are scared of getting into trouble, like the previous lawyers. So like make them feel safe that there's a way they could use it without getting into trouble.
Make them feel safe that without getting into trouble. Okay,
Yeah.
we'll try. So AI in general, the primary hallmark is speed. All right. One of the biggest complaints that we've heard from lawyers and even myself is that you don't want to sit down and stare at a blank page. If you've got a motion for a continuance, that's simple. It's, hey judge, I've got this, life event coming up. Can I get a extension on this? My opposing counsel has already agreed. That's pretty simple. Okay, you can use a fairly basic template for that. Case Create doesn't really have one of those, even though you can use our general motion drafter to draft it if you want. But the idea here is that you need words on a page so that you can edit. A lot more attorneys would prefer to edit a document than start from a blank page. Well, with AI, you have the ability to input your facts and request that it drafts something for you. At the end of the day, AI really is just a very large very complex predictive text generator. It gets trained on, in my world, publicly available documents in order to spit out another document that looks similar to what it's already been trained on, which is fantastic because, American common law is based on English common law, which is based entirely on precedent. So nothing that I do reinvents the wheel. There is no pleading that I make that is something that hasn't been done already. So when you take this text creator, this predictive text generator, and you apply it to law, it drafts really fast. Allowing you to effectively give someone in your office, we call them lowest cost, most capable hands, hey, here's what I need you to draft, here are the facts surrounding that situation, and then here's the law, or do some research, find some law that applies to this, and then give it to the AI to draft, and you'll get a result. Case Create, because you did tell me to kind of alleviate some of the fears that people had, Case Create is specifically programmed to not generate fake cases. So we'll start there. In order for the software to work, you are required to put in your request, your facts, the facts of your case, and your law. Meaning that whatever you research, you pull out of Lexis, pull out of West, pull out of Fastcase, your favorite platform, you take your cited legal points and you put them into our software with a citation, and it will do its level best to give you a document that applies the facts that you've given it to the law that you've given it and reach a conclusion based on the conclusion that you want it to reach. We don't generate names. And so if people don't want to, they don't have to put in the name of their clients. That's perfectly fine. You can use plaintiff, defendant, person A, person B. The software recognizes some of those substitute nouns or substitute proper nouns. What else? Yeah, we can get into security specifically, but I want to stop rambling and let you ask the next question. Did that answer your question?
Perfectly, it did. It did.
Awesome.
Thank you. So the next question is about legal liability in AI. So who should be held responsible when an AI tool generates an inaccurate answer, maybe in application to a legal case or anything related to the legal industry profession? Who should be?
The answer to that one is 100% on the attorney. Whenever I sign a document, that tells the court that I have done the research, I have applied the facts, I have done the best I can, within that limited I've done the research, I've applied the facts, I've done the best drafting that I can do, with regard to that document. Now, if I choose to write it 15 minutes before the deadline, that's on me. But generally, I'm certifying by my signature that everything in that document, including the facts that I've cited, the cases that I've cited, everything in there is true and correct, roughly. Okay? Well, with my spin on it, of course, because litigation. But I have a list, or I keep track of some law firms running lists, and there are a number of courts, I believe it was about 11 last time I checked, that are requiring certificates of compliance with, certificates of compliance or certificates of AI usage or something like that, where the courts are basically asking the attorneys to certify that either they have not used AI, or that if they have used AI, that they've checked it and verified the citations and the facts and so on and so forth. Ultimately, I believe that that's a little bit of a knee-jerk reaction, and we can kind of talk about that on the impact to court, or if you want to talk about the impact on the courts later. But I believe that that's a little bit of a knee-jerk reaction, because ultimately, even if I don't use AI and I miscite cases, the court still has the authority and the ability to sanction me or disregard my motion or consider it non-responsive and strike it. Like, they can do a number of things regardless of whether or not I used AI. A certificate of AI compliance or whatnot doesn't take away or give the court any more power than they already have. So ultimately, it does fall back on the attorney to get it right. We even have in Case Create, we have a section where if you use our AI, you have to click accept on our disclaimer to show that we're not responsible, for what comes out of the system. Like, you have to check it. Even when I use Westlaw's AI research tool, at the bottom of every result, they say it did the best it could given what you gave it and the limitations of what we have. But you need to check this, on your own. So definitely on the attorney.
Okay. It almost seems like you pipped into my note because you said impact of AI on the courts. So there's two perspectives to this question. Predictive analytics. People who use AI tools to predict what the outcome of a case would be. What's your perspective on that? And also the impact of AI on courts. Are they proactive in their responsiveness or otherwise?
So let's start with the predictive analytics. I will tell you right now that I do not like AI and predictive analytics because you can give AI all the data you want to. Okay? You can give the AI absolutely everything. But the one thing that you can't give it is what the judge had for breakfast that morning. Okay? If the judge is lactose intolerant and somebody slips some milk into his oatmeal, the judge is going to have a bad day. Okay?
Right.
If the judge wanted cheesecake for lunch and the restaurant, or if the judge didn't know that they were going to have cheesecake that day and somebody handed him a free slice of cheesecake when they were off at lunch, that afternoon's hearings are potentially going to go much better than the morning's hearings went. Okay?
Right.
So while you can feed AI data and the system will say, well, in this particular circumstance, the judge gave in 57 or 67% of the time, the judge liked this language inside of this particular motion, and therefore if you include this language in this motion, you may be putting yourself into this 67% bucket. It doesn't take into account a number of factors that you just can't see, which is, does the judge like your face that day? Does the judge like your attorney in particular? Okay? The judge doesn't like the lawyer? There's no amount of predictive AI that's going to, allow for that. If the judge is feeling in a pensive mood, no amount of AI is going to predict that. If the judge has a meeting that afternoon that they really need to get to, they can't be called back on appeal if they deny a summary judgment. So you've got one movement making the time out to write a summary judgment for 10 hours using all the things that the predictive analytics say to include on this. The other side spends another, 10 hours responding to it. They both get to court. The judge has a meeting. The judge knows if I deny the summary judgment and it proceeds to trial, there's no interlocutory appeal that can be granted for the denial of a summary judgment. Therefore, I'm going to deny it and get the heck out of here to go to my meeting, and your predictive analytics were wrong. Like, what? There's nothing that can be done about that. So I don't like them. I know that there are a slew of companies out there that specialize in them. I don't care one whit for them at all. It's more important to know the judge and knowing what they're doing that day. And I think you had one more question. What was it?
Yes, the impact of AI on courts. Are they proactive or otherwise?
So that's an interesting question, and it's one that if any of your podcast listeners are judges, and I'm going to put it out and make sure that some of them are, one of the things that I, in Case Create, want to do is that we want to work with some of the judges and some of the systems that are designed to propagate the rules of civil procedure at both the state and federal level. We want to work with them to have practical guardrails around AI and the usage thereof. So I'm going to give you some examples here, but let's go back to one of the things that was mentioned earlier, which was that the knee-jerk reaction that some of the courts are having, right? So some of the courts basically said, you are going to certify whether or not you used AI, and if you used AI, then you checked it. Okay, great. But like I mentioned, that doesn't abrogate any responsibility that the attorney had, or it doesn't take away any of the powers that the court had. At the same version, it doesn't give the attorney the ability to skate on mistakes that they made in misciting cases, and it doesn't give the court any more power than they already had. The court already has virtually unlimited power to face check attorneys for getting stuff wrong, okay? Judge Brantley Starr, actually the first one who created that AI certification in the Northern District of Texas, I made a mistake in his court at one point in time, and without so much as a thought, I think that it was just a routine practice of that particular judge, he made me write an explanation of my mistake, send it to my client, and then file with the court proof of the document that I had written explaining my mistake and proof that I had sent it to my client, okay? That was before AI was ever a major thing. And he's like, okay, well, this is embarrassing. I won't be making this mistake again. So message received, judge. But a certificate of AI compliance does not give Judge Starr any more power than he already had to tell the attorney to go back and tell their client what sort of mistake they made. That's what the courts are doing right now. What they need to do is they need to take a look at the impact that additional speed will have on the actual practitioners during the litigation itself. So one of the things that I've done in my own practice is I had a set of plaintiffs. There were 3 plaintiffs. I represent all 3 plaintiffs. And then I was suing 2 defendants. Okay. Defendant 1 was the owner of a company. Defendant 2 was the company that that person owned, right? Well, when you do some basic multiplication, I've got, assuming 25 interrogatories, 25 requests for production, and 25 requests for admission per plaintiff, that gives me 75 questions per plaintiff that I can ask to one defendant. Well, I had 3 plaintiffs, so that gives me 225 questions that I can ask to one defendant. Well, then I had 2 defendants. So now I can ask a maximum of 450 questions. I sent counsel 237 discovery requests, and I was able to generate them and clean them up in about 4 hours. Okay? When I sent them over to him, under the rules of civil procedure, he still has
you created them using Case Crafter, right? Soon to be Case
Yes.
Create. Okay, that's
We
AI.
absolutely used them, or absolutely created them using Case Create. Like, there's no other way that you can sit there and efficiently draft 237 questions. Like, that would take hours without the use of a computer system that was helping you put those together, right? So we what is the word I'm looking for? I sent those over, and under the rules of civil procedure, he still had 30 days to answer them. Well, he sent back 100 and some odd objections on it, and we've got another part of Case Create that's able to parse through those objections, find out which ones he's repeating, and then show the judge in a motion to compel how many times he's repeated a specific objection without providing any sort of supporting explanation for it. And we're able to do that in an hour, maybe two, as opposed to going through and handpicking each one of them.
Wow.
What the rules of civil procedure should say is something like an opposing party has 30 days for every 75 questions that they get from all sources, right? That way, I would then have to make a choice of, do I want to delay proceedings by giving him 90 plus days to respond to 237 discovery requests, or do I want to go ahead and get this done in the ordinary 30 days and then send it out? The rules of civil procedure don't take that into account, and I believe that that needs to be mentioned. On top of that, I have the ability to create motions for summary judgment in minutes on every cause of action and every affirmative defense that are contained within pleadings. And I can set them every 21 days. And all I have to do is move the hearing. The rules of civil procedure don't have any reason why I can't keep opposing counsel chasing down my summary judgment motions for 6 to 8 months at a time, right? On top of answering heavy discovery and still having to put their client up for deposition. So based on the speed alone, I can be extremely abusive. And there's nothing in the rules that say that I can't. And even if a judge or one of my opposing counsels hear this podcast, there's still nothing that they can do about it because the rules allow me to do everything that I'm doing. And I personally believe that that's going to get annoying at some point in time. So the court should address it sooner rather than later.
Yeah, hopefully someone out there who has the power to do something is listening to this. Well, because, I'm just having compassion for the judges. It's going to be a lot at some point when a lot of people begin to use Case Create or other AI tools, but hopefully Case Create. You're about to say something.
It's actually not the judges that you need to worry about. It's the individuals. It's the individuals who are paying the bill, because somebody sends me 237 discovery requests. I'm billing for every minute that I have to spend responding to them, right? And in order to respond to them properly, that's going to take time. So it increases the cost of litigation. So AI is a double-edged sword. On one side, if you are the type of attorney who just wants to get through a JP case quick, fast, and efficiently, because you're trying to make that $1,000 plus or minus, worth your while, it's an extremely efficient tool. On the other side, if you are a white shoe law firm, or if you're one of the larger law firms, or if you're just, one of those scum of the earth type attorneys who only want to bill your client for as much as possible, you're going to generate as much of these documents as possible, or you're simply going to not use AI to make your practice more efficient. And then your clients are the ones that ultimately get slammed with that bill. And the law firm doesn't care because they're going to milk you until you can't pay them anymore. And then they're going to drop you. So now the client is in a situation where their cost of litigation has increased exponentially, and the attorney and the rules of civil procedure aren't addressing that, to protect the actual people that the court system was designed to protect. So it's going to be an interesting issue, but don't feel sorry for the judges.
But so, a question I had was AI's impact on the cost of litigation. You've probably talked about the time, but the cost, especially on the client. So what exactly can be done before it actually gets worse? Or does it have to get worse before something is done? Because we're talking about the pockets of people here, money.
So that's an interesting question and a complex one. It's definitely the first time that I've been asked that, I believe. But The impact on the client should be a transparency of fees. So in the litigation field, we have a couple of precedential cases, or a couple of, I guess, cornerstone. I can't remember the name right now. But we've got a couple of cornerstone cases regarding how attorneys can bill. Most importantly, it's like Lodestar, using the Lodestar method, and El Apple, which was a decision. I don't remember if that was Supreme Court of the U.S. or Supreme Court of Texas. But basically what we've got is you prove up your billing by telling the court what you did for every minute. So if I said, if this was part of a bill, I would say, recorded podcast with Tolulope. But on your bill, you would see, podcast with Tolu, 0.75 hours, right? Discussed benefits and drawbacks of AI usage. And then I would put that in front of the court and say, I, Aaron Cartwright, here are my credentials, billed 0.7 hours on this day, here's why. Okay? That's the way that everyone in the United States that litigates is commonly able to do, or is commonly doing, client billing. Under those methods, however, we are allowed flat fees. It's just that very few people, very few firms are interested in the use of flat fees because they haven't really had a reason to. They make more money putting a butt in a chair for 4 hours than they do just billing the client $1,200 and getting the thing done and out the door, right? I believe that AI is going to change the way that works. There is going to be a lot more insistence on transparency. We aim to make sure that the clients are aware that they can request a certain level of transparency, because using our tools, using tools that are based on AI, the attorney is able to do a lot more in a lot less time. But that doesn't necessarily have to compromise their fees. So one of my favorite examples is I charge $1,500 for a petition, and that is just my price, okay? Plus you have to pay filing and service, but I charge $1,500 for a petition. My clients know at the beginning that I am charging them $1,500 for a petition. How long it takes me to draft that petition is then my problem. If it takes me 18 hours to get all the facts straight for that petition, I've lost money, or my effective hourly rate drops down to $25 an hour, or whatever that is, or whatever that number is. Okay. Whereas if I'm able to say, hey, the facts of this case are relatively simple. It's something I've seen before, since I practice only within certain areas. This is something I've seen before. Give me all of your facts. I get all of their facts on a phone call. I use an AI to transcribe the phone call. Now I have the client's story in the AI, or in the transcript. I take that, I feed it into Case Create as part of my facts section. I feed in the applicable law to the law section, and then I make the request, reach the conclusion that so-and-so breached this contract. I click draft, bam. I now have an effective petition within a couple of minutes. I still make $1,500. My client now has a lawsuit. The client knew that the $1,500 was there, and then on my billing, I can tell the court flat fee rate for a petition, $1,500, right? And I can either give it to them in a flat rate, or I can break it down into the hourly count. But there it is. I prefer I prefer the flat rate because that's more honest. You can, and another attorney can say, well, did you actually spend 4.5 hours on this? No. The client paid me $1,500, and therefore reasonable and necessary attorney's fees that your client is now responsible for is this person's $1,500 that they paid me. So transparency is a big one. we're going to see another shift, or we're going to see a much larger shift to flat fees. It's already big in the transactional world. Some litigators are trying it out. There's, Facebook groups and smaller movements dedicated towards flat fees. I think that with the advancement of AI, we're going to see a lot more flat fees used in litigation to kind of benefit the clients as well as, maintain a firm's bottom line just so that they can keep operating.
Right, right. I was even about to say so. So that means we're headed over to flat fees, but you already said are you in my mind today?
Yeah, I mean, you're already in this space. You know what's coming down the line just as much as I do.
True,
But
true.
yeah, you're still going to have some attorneys. Again, larger law firms are the bigger culprits of this, but you're still going to have, the really large law firms that make more money billing hourly doing their thing. But when just like 99% of people aren't in the top 1%. If you're not in the top 1-2% of law firms and their billing practices, then AI is just going to benefit you in general. I'm not necessarily worried about the people who want to hold on to the antiquated way of billing just because that's how they squeak more money out of the client. That doesn't sit well with me, so I don't care about them.
Right. AI in ADR. I've not really heard a lot about that. Is it being used and how?
So that ties into another thing. So that ties into whether or not, we'll kind of see AI replacing attorneys or AI replacing judges. The reason why it does is because in an ADR situation, so for example, I'm a licensed or credentialed mediator in the state of Texas. I've taken the classes. I get called for mediations every so often. I haven't made it a part of my practice, but I really enjoy doing it. In a mediation, there is a lot of human element that you will have. There is a lot of, I want to tell my story. I have been wronged. Somebody who is not my attorney is going to listen to this story no matter how many times I have to tell it. So in a mediation, in a 4-hour mediation, I have been in 4-hour mediations as a mediator and as an attorney. And in the vast majority of the time, unless you've got sophisticated parties, people will spend the first 3.5 hours out of 4 talking about how they feel, talking about the grievance, talking about the impact that it's had on them, trying to get the mediator to see their side of the story, trying to get the other side to see their side of the story. And the first couple times you do a mediation, it's mildly disconcerting, but after that you realize that that's just a necessary part of the process. So within the mediation sphere of alternative dispute resolution, one of the solutions that AI has, or that you can kind of incorporate into AI, is that with the right programming, you could potentially expand the options, given a certain set of situations, giving the experience of the mediator, depending on, how long the mediator's been mediating and how much effort they actually put into the mediation. And I'll actually address that here in a second. You can use AI to give a series of facts, a very complicated series of facts, and then you can use that to expand a series of options that may not have occurred to the parties and or the mediator. Okay, so that's one way of doing it. And the reason why I say that mediator thing is because there are good mediators, there are bad mediators. Good mediators will obviously try and expand the pie. In my opinion, good mediators will make suggestions to all parties based on the facts and the situation that they're seeing right now or right in front of them. Bad mediators phone it in. Bad mediators will go back and forth between parties and they'll just convey offers back and forth without actually making any suggestions or without, really pushing for one side or for both sides to see the other side's, strengths of the other side's case. So it'll help bad mediators be better, although that's really kind of a personal thing, but it'll also help good mediators be great by hopefully, presenting options that people didn't ordinarily see or think about just in case they weren't in that mindset. So that's mediation. Then with arbitration, you're not going to see a lot of, you'll see, preparation of litigation documents because that's what arbitration is. It's just private litigation. with a judge that you pay for on a timeline that you set. And so you're going to see a lot of, litigation documents being created by AI. I don't think you're going to see a lot of judicial input on it, because whatever solution gets sold to the state regarding litigation, which hopefully we're working on, whatever solution gets sold to the state with regards to handling AI is the same solution that you're going to see a lot of the arbitration panels and arbitration organizations adopting as well. So it all depends on what the judges start saying they like.
Awesome. So two more questions, and then we'll go to the second part, which is a walkthrough of case create. So the first is about how can AI help in understanding complex regulatory frameworks?
Oh, you're stepping outside of my area of expertise. You're now talking about education. Well, the only thing that I can say is
Well, you're
that
smart. I'm sure you killed this question. You're smart.
we'll see. We'll see. Let the listeners decide. So as far as complex regulatory frameworks, the only thing I can see is you taking a regulation, a concept that would ordinarily be difficult to understand, feeding it into an AI system, be that ChatGPT, Claude, Bard, any Copilot. I think that one's Microsoft. I know who owns who. I know that Microsoft has its hands in a large number of AI pots. So I don't remember. I know that they own, or they've contributed to, part of ChatGPT. They've also got Copilot, and I think they've got their hands in one more, but I'm not sure. But Google owns Bard, and then somebody has Claude.
Anthropic.
Yeah, Anthropic has Claude, but I don't know who's invested in Anthropic. It's one of them. So if you feed it into your favorite AI system with the idea of, hey, I need you to simplify this concept, and give me an example that goes with it, then it should be able to give you a response in more layman-like terms. Now, you're still going to have to go back and do the research and confirm what AI says, because again, right now all it is a predictive text generator. It cannot pass the Turing test within some limitations. We're not going to really talk on that one, but the Turing test is the idea that if I'm sitting down next to you, or if you and I are sitting in different rooms, we think that we're talking to each other, but in actuality, we're talking to an AI. If you can't tell the difference between the AI and a human, then the AI is said to have passed the Turing test. It sounds human-like. Whereas if you can tell I'm speaking to a machine, then it has not passed the Turing test. Right now, with everything that Case Create generates, you can tell that something generated it, even though you can still go back through, clean it up, add your voice to it, so on and so forth. But even in the context of understanding complex regulatory frameworks, it will give you a response, but that response is still going to be from the perspective of a machine. So you need to go and line by line and make sure that, okay, now my understanding is being helped out. But then when I say that goes to the education, there are education companies that are currently working on how to use AI to narrow down where their students are failing, or not failing, but not succeeding as hard, and kind of teach them those difficult to understand concepts. You'd have the same thing here.
Awesome. So you mentioned this earlier, security and also other ethical issues associated with AI in the legal field. So could you expand more on that?
Sure. One of the concerns that a lot of people have regarding AI is the security, right? So if you are my client, can you be assured that my data isn't just going out into the internet, right?
Right.
So that is a major thing. The way it generally works is that if you use the free tier of Claude, Bard, ChatGPT, then they will use the questions and answers and names and everything else that you put in there to train their system. that's a drawback that you accept whenever you're using the free tier of that. Whenever you're using the paid versions, they start to say that, they're not using your data to train. And I didn't do much research on that one because I went from the free tier to the API access. And so with the API access, you can think of API or an API key as kind of a pipeline. I put something in one side, it goes through the pipe, it comes out the other end. Except in this particular instance, the other end processes that information, it goes back through the API, and then it outputs on our side, right? So that's what CaseCrafter uses, and our system is built off of ChatGPT's API access, okay? Or we've got a couple of API keys that we use for our access to ChatGPT. I'm reasonably certain that I slaughtered that explanation. But our data, we have made it to where any data that you put into our system, there is a hard reset after 30 minutes. So it's completely gone. There's no cookie on your computer where you can recover it. There's no cookie on our side where you can recover it. There's no reset function, backlink, or anything where you can say, oh, well, I see, I can see these names and information given here. So that's one of the steps that we've taken. Second step, obviously, is ChatGPT's API access. They say that they, A, are not using your data to train. B, if you've kind of paid attention to it, the way that the system uses that data does not come out in a human-readable format on anybody's end, even on ChatGPT's side. I'm certain that if they really wanted to, they could find it, but they don't care. Okay, their job is to process. It's the same thing as Google having the ability to look at all of your emails. Even as an attorney, you're not concerned about Google having that access because A, you need your email, but B, Google's business has nothing to do with what's inside of your emails. ChatGPT's information or system does not care about what you use it for. They only care that CaseCreate is paying them for that access. Okay, so you can rest assured that your data is not being trained, CaseCreate isn't keeping it, and ChatGPT or OpenAI doesn't necessarily need it. On the flip side of that, you can also take steps to anonymize your own data. So instead of saying Aaron and Tolu entered into a contract, person 1 and person 2 entered into a contract. Person 1 did this, person 2 did that. Boom. Now, whenever it goes into the AI system, whichever one you're using, even if you don't use CaseCreate, the system doesn't have the name of your client. And additionally, it is never a good idea to put the names of minor children inside of anything at all, except for your own personal case files. So in my practice, I don't even keep social security numbers of clients. Like, I just don't. We take every security measure that we can, but the biggest one is just the simple common sense act of not having that data. If our system doesn't have the name of your client, our system cannot possibly misuse the name of your client. Simple.
Wow. Okay, so I could go on and on and on, but yeah, because you're a good conversationalist, and I just love listening to you and learning.
Oh, I feel like I'm rambling.
No, you're not. You're not. You're making sense. Okay, so what are your final thoughts before we go to the second part of this episode?
It's coming, everybody. It's coming. It's already here.
What's coming?
The mass takeover of AI in every aspect of the legal field. Like I said,
is AI going to replace lawyers? What do you mean? Replace
so
lawyers
it's
or
not
replace
going
the
to
legal tasks?
it's not going to replace lawyers or judges, but there is going to be, number one, if a client should ask an attorney, are you using AI? And if so, how? How does that benefit me? Okay. If it's something like CaseCreate, we're giving our clients, the information they need to be able to answer that question. If a client goes to an attorney seeking legal services and they specifically say something like, well, we're not using AI, to me, that's a giant red flag because it means that they're not interested in being efficient with my money. And if the person on the opposite side of me is using AI, it's entirely possible that my attorney could be blitzed under from the sheer speed and volume of the documents that can be generated and passed over. And that reflects poorly on my bill, because now my bill goes up when I asked for an attorney that that should have been doing something more efficiently. So, an attorney that doesn't use AI is going to be in a bad way. An attorney that uses AI is going to have more time for themselves. You can do more work in less time, or you can use the same 8 hours to just handle more clients. Whichever. Are you going for more money, or do you want more time in your life? That's the great trade-off everywhere. AI is going to help the attorney or the practitioner see their way through to that while still benefiting the client. From the court side, I hate to say this, and it'll be addressed with the judges whenever we get around to adjusting the rules of civil procedure, but the speed at which things can be filed is going to overwhelm the courts and the state system if the courts and the state system don't adopt some form of responsive software that, if nothing else, helps the judges consolidate. And I'll freely admit that this is something that we're already working on. Help the judges consolidate what's in front of them and go through and actually start finding, basically kind of what we call a hot bench, right? So if there's something out there that helps judges consolidate, point being, helps the judge see all the facts and all the law in one spot, which is obviously something that the judge's job is. But if there's a way that the judges can see all that in one spot, in a hearing, the judge can go through and say, all right, confirm this fact, confirm this fact, confirm this fact, confirm this fact. All right, now that we've got all the facts confirmed, let's go through the law that you guys have cited. Here's the, law regarding a motion for summary judgment. You've got a breach of contract that you're trying to get summary judgment on. First of all, do we have, can parties agree that there was a contract here? Okay, you say that there isn't. You say that there is. This person says that there's a sheet of paper right here. I see a signature. I see a clear scope of work. I see an amount. Bam, it looks to me like we've got a contract. Move on to the next part, all the way down. Basically, helping the judges see things like that will help them more efficiently manage their docket. All right. If not, you're going to have small cases take years to get through, and it's going to be an absolute snarling mess.
Wow. Okay, so everyone, we're not over yet. This is just the end of the first part. So if you would like to see how Case Create does its magic, how it's innovating, legal case management generally, so stay tuned and just look out for the second part, which would be pinned, I don't know, here or there, somewhere. And if it's on Spotify, you can just check the next upload. All right, see you guys in the next part. Bye.
Bye.